Okay. All right, ladies and gentlemen of the jury, we're going to take a brief recess, give you time to handle any matters you may need to handle. We need to handle little business matters as well. I'll try to bring you back as quick as possible so we can continue, okay? Please, you go with Deputy Miranda. Off the record. Okay, everybody, thank you for patiently waiting. I know you guys want to go. Let's go. Come on. Hi, Cena. What you got, bud?
Hello, I was the meeting in your case. It's a reckless driving case.
Okay.
Discussing it. She's been in trial, so yeah.
Have we done PC yet?
No, it's very new case. Okay.
Let me split.
Yeah. Oh. After 267, I'll be right back. After up to 267, I'll be right back.
Jason, what was the last name?
Alzabine, A-L-Z-B.
I got it. Okay.
Z-A.
You do work with Betty, right? Okay. Mr. Albazin, come up.
Well, Judge, when we send you so different about.
He's got 4 total.
Good morning, sir. You speak English? Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Thank you, Your Honor. On April 10th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling at a high rate of speed, failed to signal a lane change, weaving in between cars, and following too closely behind other vehicles. The law enforcement officer matched the defendant's vehicle at approximately 100 miles per hour. A traffic stop was conducted, and the law enforcement officer made contact with the defendant, who stated he did not know he was going that fast.
Okay.
And if I could, Your Honor, just real quick, basically we have had the opportunity to look at the videos. My client has a radar chip in his car. We've shown it to the state. His car wasn't going over 90 miles an hour, and he clearly using his indicators. And on the video, the officer says that he doesn't know how fast he was going. His car has no radar, but he thinks it's 90 to 100 miles an hour.
I mean, you're going through video. This is just probable cause hearing. We could set it for something, but
There is no actual speed that he paced my client. So there is, just to let you know,
speeding in and out of traffic, falling too closely.
according to the officer, right?
So I'm going to find probable cause for
That's
now.
fine.
We can always set it for, because I have to give them the
No,
opportunity.
absolutely, Your Honor, absolutely. I
So,
think the chief, once he's, done with this trial, he's already told me it's going to be either a class dismissal or straight up dismissal.
Mr. Albazin, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in this manner again. If I find that you drive at speeds of 90 to 100 miles an hour, doing reckless driving, weaving, I'm speeding, I'm going to revoke your bond and put you in jail. Just, we have enough crashes on the road. Don't add to it. You know what I mean? No reckless driving, racing, street takeovers, donuts, nothing of this matter. Got a great lawyer. He's going to help you out. Just stay in touch with him. We'll give you guys time to work on the case. I'm going to have bond conditions created so you promise us that you're not going to drive like this. If I find that you do, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay, so we'll have you sign a reset. Just have him take a seat. We'll get bond condition created, and then once you sign it, at that point, you can leave. Leave. Can you file that, guys, please? So no.
I wanted to reapproach on Justin Harris. I know I just missed it by a hair. I was upstairs in another hearing and I wish I knew about it.
No, I've never refused or denied a waiver withdrawal.
Because it's in your power to do so, and obviously you haven't seen.
And are they still coming here today?
They're here right now.
Then I'm not gonna grant this waiver withdrawal. Let them know. They're here
I
from,
can't let him know. Well, okay, I'd love to let him know.
they send them down already?
Is there any reversal?
Is there a way to communicate to where he's going?
We're going back to jail, so he's already in time for head to jail, so that they know we expect.
And
Okay, so let's do this. I'll reach out to my court manager to try to tell admin to let them know.
It's like something, and I'll let his family members know, but I don't mind even going to the jail, but I think that I won't do it.
No, I'll call my admin right now.
Sylvia?
She can get it. Yeah, she's
She's magic.
gold.
She's magic. Do you want me to wait, to see if he gets brought up, or y'all can?
No,
just pass him on?
we're not gonna get him back up.
Just pass
They're
him
saying
back.
he's in transit back and then which is good because that way they can get him to
Right, and-
Pennsylvania.
Right,
Let me
and
just
it's,
step out.
sure, you know, it's e-filed, so I don't know what you do electronically, but,
I can unsign it.
okay,
That's not a problem.
Okay, thanks.
Reach out.
Thank you, Judge.
Wait a second. What was the name? Hi, good morning.
Justin Harris on the fugitive docket.
Justin Harris?
I know. I kind of laughed at that, too.
I'm just kidding. I'm just kidding.
It's funny, 'cause I just seen him yesterday. Justin Harris is on the fugitive docket. He waived at magistrate court and has vehemently changed his mind.
Should we? You're laughing. Do you want me to bring him out?
So Judge, if you want to bring him out and admonish him, Philadelphia, from what I hear, does want him. Is that right, Amy?
Yes, we're on their way here to get him today, but if he's withdrawn his waiver, of course they can. If he intends to withdraw his waiver today, they obviously can't pick him up today, so.
If they're gonna get him, they're gonna. Hey, Deputy, you mind bringing out Justin Harris, please?
And then while he's coming out, do you want me to reset the Dustin Eli hearing?
Have they done anything upstairs? It's on docket today?
No, they haven't. So I was going to talk to you about that. If he takes TDC up there, would you consider?
If he takes TDC, there's nothing I can do.
I agree. And that's, I mean, and I hate to say that because I don't know what they're doing, but if we could
Obviously,
reset it, I think it's an option.
No. If
Okay.
it takes TDC time,
Okay. And I hate to say that because I don't know what'll happen in May,
no-
but I think it's could be worked out. Yes, Judge. Your other option was to put him into state of.
No. My feeling is that he's probably gonna end probation, right?
No.
Really? Have they not offered probation upstairs?
They might, considering the nature of it. If they do, they're going to require state of, right?
I mean,
Right. And that's the end goal is I don't think he wants that.
he's willing to go to TDC instead of going to treatment for real?
Yes, I know.
Well, I mean,
I've talked to him. I know, and I'm going to set up another meeting with him to go over things, but
be the horse to water.
you know, there's only so much I can
I know.
admonish.
Yeah, so
They just.
that case is set for May 12th,
So
I guess.
if I can just get like a day or two after that.
Absolutely. Good morning, Mr. Harris. Good morning. So you're wanted out of another state. You already waived, and your lawyers tell me now that you would like me to set you a bond so that you can go out and go turn yourself in.
Oh, no bond. I just wanted him admonished on the extradition timeline.
Okay, so you've waived. What happens is we give the demanding jurisdiction, which is who?
Philadelphia County, Pennsylvania.
What's he wanted for?
Murder, endangering welfare, and
Okay, yeah. So you're wanted for murder and what else?
endangering welfare. And then the third charge, that's REAP.
Well, they,
Rape?
It's they spelled it REAP.
ain't no damn rape. I ain't rape nobody.
I don't know exactly what that one is, but for sure.
So understand that we just get the teletype that tells us what it is. I have no idea. Here, we don't fight the case. We only try to establish identity. If you are the person that is wanted from the other jurisdiction, I don't know. The good news is though, is that you've waived and they're coming to get you today. So we could really get you on the way back to Philadelphia today.
No, I said I'd rather put the 30 days in. Didn't I tell you that?
You did, but I'm just admonishing you. It's not just 30 days.
So
30
what
days.
happens now is,
Yeah, 30
I just want to make sure you understand that.
so what happens now is if you refuse, which is your right, they'll get a governor's warrant, but that'll take up to 90 days to get,
I'm
you
fine
know?
with that.
And then the pickup is 30 days after that. Just to make
Okay,
sure we're good
I'm
with
fine with
timelines.
that. I'm fine with that. Cause I'm
Right,
trying
so-
to get everything in order back to there. I'm not about to rush, be blind, go back to Philadelphia. And then I don't know what's going on inside inside my county, like, as far as being held inside, like, it just.
You want it from other counties as well?
I have no knowledge of that at this time, Your Honor. I would have to run a criminal history check if I could get one of the prosecutors.
So I guess you just want them to get a governor's warrant, then I'm assuming you did. Okay, so if you just want to go ahead and,
I'm gonna find them.
And then Judge, the waiver withdrawal should be in your queue.
Yes, it's right.
okay, I'll sign it and then, all right. So I guess let's set it for 45 days. What do you think?
I have him set out for 30 days.
Okay, not a problem.
So it's gonna be May 23rd.
Okay, so the problem is you have to understand also is that when someone is charged with a crime that has a potential life sentence, I can't give you a bond even if I wanted to. Just that's the way the statute reads. So, okay. All right. Good luck to you, Mr. Harris.
Thank you.
Thanks, Judge. Thank you.
Thanks. Hi. Ray, do you want this on the record or no? Okay. Off the record. No, we're good.
Oh, it doesn't work.
No. They were talking. Ms. Morgan, who is this?
Is this Ben here, Your Honor?
Oh, they're making it.
You want to come up right now?
Yeah, I guess so. Just so y'all can go do whatever you need to do. Yeah.
I will find out who this was, so we can get it cleared up.
Like, does she get the case in here? What's your name, ma'am?
She was my proposed victim yesterday, and Lois today, they were trying to discuss it, and all the review if they're gonna.
Oh, okay.
Yeah, Moreno.
Moreno?
Yeah, Valeria, sí.
Moreno, Valerio.
Moreno. It's way from here. She didn't even have to be here. So it's probably getting reset. So we'll talk to Vic and see. Victoria.
Yes, Judge.
Have you heard from Michael Fan?
No, Judge.
Come on. All right. You are Mr. De Mejia Nunez.
Yes.
You were charged with 2 counts of driving while intoxicated. You have worked out an agreement where they're going to dismiss one of them. You're pleading to the other one. It's 75 days in jail with credit for the 25 days that you have done. Is this how you understand the agreement?
Es el mismo acuerdo. I'm sorry, Judge.
Is this how you understand the agreement?
Entiende que será el acuerdo. Yes.
Giving up the right to a trial,
Renunciando su derecho a un
right to
juicio.
compel witnesses to testify on your
Su
behalf,
derecho a tener
confront and
testigos que
cross-examine.
testifiquen.
If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It's going to be there forever.
Permanecerá ahí por siempre.
So
Yes.
from now on,
De ahora en
if
adelante.
you ever get pulled over, an officer is going to see all these DWIs. And if you smell like alcohol or dope, it's probably not going to go well for you.
Va a ir bien.
Every day, someone dies from a DWI in our nation, in our state, in our county. Don't kill anyone.
Mate a nadie.
No mates a una persona. Because of these DWIs that are with you now, I'm telling you, anytime you get pulled over and you have a funky smell, it's probably not going to go well. So if you're going to drink, if you're going to have 32 shots of tequila, 52 beers, don't get into a car. Do you understand?
¿Entiende?
Sí.
Yes.
I'm going to suspend your
Voy a
license for 1 year.
suspender su licencia por un año.
Okay.
Do not drive until you get a license.
La
The
licencia.
other thing I'm going to tell you is I don't know what your immigration status is, but if you're not in this country and you continue to come back without permission and you get caught by the feds, it could be a 5-year federal sentence on an illegal reentry. So be careful. If you want to do things, do it the right way.
Hágalo de manera correcta.
How do you plead to the offense? Guilty or not guilty?
No culpable.
Culpable.
Guilty.
Find you guilty. I'm going to
Lo
sentence you.
culpable, lo
Good
sentencia.
luck to you, son.
Buena suerte, señor.
Okay, thank you.
Okay.
Thank you, Your Honor. May I be excused?
Hi.
I have Mr. De Mejia, the custody case.
Okay.
And Your Honor, he has 2 DWIs. I was speaking to the state regarding an offer for a time served on one and dismissal on the other.
Okay.
We were just wondering if you would accept that offer.
Yeah, I mean, I'd be hard pressed to do a time served, but, you know,
He's been in
yes.
custody for 21 days, has an ICE hold, previous deportation, no videos on one of the cases that I'm requesting get dismissed. They're not going to get it.
Okay, yeah. We do like, I don't know. So you guys, how much?
I believe
25 days.
So do 60 credit for 25 and on whichever one, you know, and then,
on the one with the
Well,
videos.
yeah, I think we were at 75, just to bring one.
oh, yeah, whatever you want. Yeah, yeah,
That works with
yeah,
me.
yeah. Okay.
All right, Judge.
And then are you guys ready to,
We're working on that redaction issue right now. So,
he said he wanted to approach on something too.
yeah, oh, this was, yeah, I can put, yeah. I don't know if you want this on the record, but
I had a quick question regarding off documents.
Okay.
252-1794. The name is Crystal Gonzalez.
Okay.
She's scheduled, her case is old, and she's required to appear tomorrow. You said she would have to appear if everything isn't done for PTI. We have her contract back. I talked to Ms. Gomez, she's the PTI coordinator. She said that the only thing she needed was the contract and proof of the device. Well, we have her contract back. And she also attempted to get the portable device, but they don't have it coming in until the 28th, which is Monday. And I have a copy of her, her contract for the portable device. Will she still need to be present on tomorrow?
Have proof that the device is coming in on the 28th?
Yes, sir.
Okay, no, I trust you. As long as you have it, then we'll set for the 28th.
Okay.
Okay, and she has to have everything done by then.
Yes, sir.
Okay, no more waived appearances.
Yes, sir.
Okay.
Thank you, Your Honor.
Yes, ma'am. Hi, Sarah. You ready?
I'm not approaching.
No, oh, no.
I'm
Come on
sorry.
in. That's okay. Hi.
Yes, we have Edelbert Rosas on docket, ROS.
Okay.
We still do not have a response on the mitigation packet. We emailed them this morning and there's an email saying it might still be under review. We submitted it 4/7.
Okay, so we'll set you off. We'll set you off 1 week for them to get you verified.
Will my client need to appear or can he be waived?
If it's not back, then no, but if it's back, he's got to get everything done. No more waived. It's 230 days. No more waived appearance. Okay.
I have Ms. Davila on docket.
Okay.
She was accepted into the PTI program, but we're trying to knock out some kinks with a no driving affidavit. I was wondering if we could amend her bond conditions to give her portable and have the county pay for it before she goes into the program.
Can't pay for it when she's in the program.
Before then?
She's on bond, I can, but once she signs into the contract and gets into the program, I cannot pay for it any longer. I pay for virtually everything for as long as I can, but once they're in it, or on a probation or on a PTI, I no longer have the authority to pay for it. If I could, I would, but I just can't. So she'll have to sign a no driving affidavit, and you can get one from Shatoria. Then once she gets the portable device, at that point, we can take off any guardian interlocks or anything else that she has. Yeah? And then, what about the DA fee? Has she paid it yet?
So we haven't yet. So we just put out her form. We got accepted on Monday. So we just got her form. She filled out her form and then they
Which form for which one?
the client intake information form.
Got it.
Yeah, so we just got that on Monday. She filled that out today. And then the no driving, she emailed me that her driver's license was ineligible on Monday as well. And so
Okay.
no driving affidavit.
Okay, so how long do you want? Okay, done. Yeah, okay.
Thank you.
Yes, ma'am. Hi, Joe.
Just coming back on Mr. Martinez,
I'm not gonna show you. Maybe I put it down.
The analytical report says alcohol concentration. What does that mean?
Are you referring to the subject results?
Yes.
So that would be the 2 breath samples that each subject administers throughout the breath test. They provide the first one, and then they provide the second one approximately 2 minutes later.
Not necessarily conceal something. Sometimes it's malicious and they wish to conceal. Sometimes they're just confused or they have inaccuracies because they're not, they're not cognitively fair enough to keep a consistent statement or verify where they're doing to and from.
Fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 16th, 2025, in Harris County, Texas, an officer observed a vehicle driving over 30 miles per hour in a school zone by pacing the vehicle and officer's patrol car. The officer conducted a traffic stop. The defendant was the driver and the sole occupant and was ID'd by their Texas driver's license and AFIS fingerprints. The officer approached the vehicle and observed an odor of marijuana emitting from the vehicle. The officer discovered a backpack on the floorboard. The defendant stated the backpack belonged to her. The officer observed 2 small bags of a green leafy substance, one weighing 0.27 ounces and the other one weighing 0.075 ounces. The officer then located a small semi-automatic handgun in the backpack.
Only I'm going to find that there's sufficient probable cause to go forward with your case. Can you run her license, please? See if she has a valid license.
Yes.
Nunley.
Yes, you currently working on getting access to that.
Her driver does himself.
Ms. Nunley, I'm going to find that there's sufficient probable cause to go forward with your case. While this case is open, I'm ordering you not to be in possession of a weapon. Do you understand? This, yes or no?
Yes, sir.
This is your bond condition. If you violate these conditions, a warrant for your arrest will be issued. You will go into custody. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, man?
Yes, sir.
Deputy Miranda can give you an application. I'll have you fill it out and I'll take a look to see whether you qualify. I need to know everything about you and then we'll take a look. If you do, we'll provide you a lawyer today. For now, I'll have you go to Victoria Center Reset and then we'll have you take a seat in the first pew back there where you fill out the application.
Martinez, we're trying to get a response on the mitigation, so you emailed, whoever's on this.
Have you heard anything on Martinez?
Aiden Martinez. We submitted a mitigation packet, waiting on a response from Chief Guys.
Okay.
Or PTI.
Yep, there's nothing in the notes that she probably hasn't answered.
Yes.
Do you want me to stand down or do you want me to probably just? Guys, so I guess as soon as he gets back, we'll start up.
Judge, can we have one that was set for arraignment yesterday? That was with the computer, so we issued a warrant. He's here.
Okay, we can do that now. Are you, Alexis?
I have it. Is this,
Joe's? Yeah.
I'm emailing Judge Dashcam, Your Honor.
Do you have anywhere else to go?
Yes, I can come back, Judge.
Please.
Okay.
Thanks.
For the case number?
Yeah.
The case number,
Mr. Pipkin?
I know, sir.
So you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14th, 2025, in Harris County, Texas, an officer on viewed a theft in progress at a Walgreens store. The complaining witness advised the officer that the defendant was leaving in a motor vehicle and that he grabbed several items of merchandise and passed all points of sale without paying for them. The complaining witness showed the officer a photo of the defendant as he was walking out of the store with 2 boxes. The officer followed the motor vehicle and observed it stop at a gas station. The officer observed the defendant as the driver of the motor vehicle and recognized him from the photo shown by the complaining witness. The officer observed a passenger of the vehicle and observed the merchandise from the store on the floorboard between her legs. The Air Slim headphones that were taken were in the back seat of the motor vehicle in plain view. The complaining witness stated she observed the defendant come into the store, grab the headphones, and walk out of the store, passing all points of sale. The complaining witness stated the female individual with the defendant grabbed a basket, filled it with several items, and walked out, passing all points of sale without any attempt to pay for the items.
Wait, so she did as well?
Yes, Your Honor.
Okay, so we have a co-defendant.
Yes, Your Honor. I believe that's the case.
I heard yesterday, or the day before, maybe Monday.
Okay.
She was here.
So the female individual with the defendant grabbed a basket, filled it with several items, and walked out, passing all points of sale without making any attempt to pay for the items. And the complaining witness stated that in total, the female defendant walked out with $388.78 worth of merchandise. And the defendant in this case walked out with $43.28 of merchandise for a total loss of $432.04.
Sir, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walgreens. Do you understand? They have your picture there. So as soon as you walk in, you're going to have about 15 eyes looking all over you every single time you go back. Do you understand me? Do you get what I'm saying? Anytime you go there, you're going to have 15 cameras, eyes all over you. As it stands now, don't go back while this case is open. I don't want you to have contact with the complaining witness in this case. Do you understand? If I have to put you in jail, it's going to be at a high bond. No more PR bonds. You missed court yesterday. I will reinstate your bond today, but this is the last time.
Yeah, I'm on side of it. I am on side of it.
I'm taking it. Don't pick up any new cases. Do you understand? I'm not asking for much, Mr. Pipkin. I'll provide you a lawyer today. And then we'll have you talk to them here momentarily, okay? Do not leave until you sign our bond conditions. Otherwise, I will issue a warrant. You understand? Can you file those conditions, please? All right, I'm going to have you go, Deputy Miranda. We'll have you sign a reset, and then we'll have you take your seat there.
What were the conditions?
So no racing, reckless driving, street takeovers, donuts.
Yes, Your Honor.
Okay, Mr. Beadle. So I signed the jail release conditions. We'll do a PR bond now, so that way she's good to go.
Do you need to bring her out?
No, I don't think so. No, I think you're good to go. You just make sure that, don't send her down until she sends a PR and then, yeah, she's here. We got it.
She's gonna be the on this lunch?
Yes. So, Ms. Roxanne, do you mind giving Ms. Lynch a PR bond, please? Okay. And then as soon as it's processed, we'll have her sign it and then she's good to go.
She's gonna sign it, or we're gonna bring her out?
Well, yeah, we'll have to bring out so she can sign it. That's why we put her on so that she can sign. Yeah. Okay, hi.
Just coming back on Mr. Martinez.
Nice. Sir, tell me something nice.
No response yet, Judge. Like I said, I have some from January that I still haven't received responses, so March. Can we get like a week reset, Judge? Okay, right, thank you. Parents wait. Okay, thank you.
Unless there's approval or denial at that point. Yes. Okay, thanks, Jim. Shreya. Hi. Hey, where's the other prosecutor? Where's John?
Yes.
Where's John, the other prosecutor? Do you know?
No.
Hey, Cole, can I borrow you real quick so we can do PC real quick?
Yes, Your Honor, of course. My apologies.
This is Mr. Bias. B-A.
Mr.
All right, Mr. Bias, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Can I get the name one more time, please?
Let me give you a cause number.
Yes, Your Honor.
Tell me when you're ready. 256
256
0257.
0257. All right, thank you, Your Honor. On April 15th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling on the Gulf Freeway. The officer visually estimated the motor vehicle speed to be between 115 and 120 miles per hour in a 60 mile per hour zone. The officer attempted to catch up to the vehicle and observed approximately 15 to 20 lane changes from across all 4 lanes of traffic around other cars that were obeying traffic laws. The officer had to travel at speeds in excess of 120 miles per hour to catch up to the defendant's motor vehicle. Officer caught up to the motor vehicle and paced it at 115 miles per hour for approximately 1/4 mile. A traffic stop was conducted and the defendant stated, "I effed up."
Run his license, please.
Yes, Your Honor.
Mr. Bias, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive in this manner anymore. If I find that you're a danger to my public, it's not going to go well for you. Do you understand?
Yes, sir.
I will revoke your bond, put you in jail, and no more PR bonds.
Yes, sir. The license is open.
You are not allowed to drive unless you have valid Texas driver license and liability insurance in your name, and that is a condition of your bond. If I find that you do, or you drive without, likewise, you will go to jail, no more PR bonds. We are going to reset your case to give you time to hire a lawyer. I'm going to have the state create bond conditions that you're not to drive in a reckless manner. You're not to participate in a racing street takeover, donuts, anything of this nature. I will do everything in my power to protect my city at all costs, Mr. Bice, and I want you to understand that. And if I find any more of this, it's not going to go well for you. Do you understand?
Yes, sir.
Do you mind filing those conditions, Cole?
Yes, sir.
For now, I'm going to have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. Once you have signed them, then you'll be free to go. Please. Hi. Okay, hi. Come on up. Yes, sir.
This is an off-docket case, Judge.
Okay, what's your cause number?
255-8479.
On Billings.
Yes, Judge.
Okay,
He was present here in the courtroom. Police made contact, did not arrest him until the blood test came back. The warrants have now been issued, so we're here to address that.
Can I bring him out?
Yes.
You get the cause number?
Yes, sir.
Go ahead. Hey, this is a new case.
Nathan, sorry.
41720.
This is a new case. You are Mr. Billings?
Yes, Your Honor.
Mr. Billings, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high level of alcohol. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, cool.
Thank you very It's not loading for me, just one second.
Roxanne, did you get this cost number? I need to give it to you. It's a new case. 255-8479.
Thank you, Judge.
Sure, let's go.
On December 7th, 2024, in Harris County, Texas, officers responded to a motor vehicle accident. The officer arrived and observed two vehicles that had been damaged and rendered inoperable. The defendant was ID'd by his Texas driver's license and ID'd to be the sole occupant and driver of the motor vehicle. The officer relocated the scene to a nearby parking lot to safely conduct the investigation. The officer determined the defendant was at fault for the accident after speaking with all the parties involved and reviewing information collected at the scene. The defendant stated he had left a bar called Sugar Room. The defendant stated he drank 2 beers at the bar. The officer noted that initially the defendant was not even aware that he had been in an accident. The officer observed the defendant to be lethargic and confused. The officer observed the defendant to have slurred speech, glossy eyes, and trouble maintaining their balance. The officer had to ask questions multiple times to obtain simple information from the defendant. The officer did not notice alcohol emitting from the defendant despite defendant's admission to drinking and defendant's apparent physical and mental impairment. The officer suspected the apparent impairment of the defendant could have been caused by some kind of narcotic. The defendant refused to perform standard field sobriety tests. The DIC was read. The defendant agreed to provide a blood specimen, and the lab results came back to a .17.
Okay. Any prior to DWIs? And does he have the first and valid license?
His license was recently suspended ALR. He will not be driving. He has a 90-day suspension.
Okay. I want you to understand something, Mr. Billing. I take this extremely serious. I don't care what you have to do in your life. If you do not have a valid license and liability insurance, you are not allowed to drive, and that is a condition of your bond. You will be signing an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building and you have to say 50 kids. Do not drive. Do you understand?
Yes, Your Honor.
Nothing you can say justifies getting into a car and driving. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you if and when you have to come back to court. If you get called upon to go take a test and you fail to go, a warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Okay. Now, I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you'll sign a reset. After that, you'll get to Roxanne where you will get your bond conditions and then you're free to go.
Thank you, Judge.
Thanks. Okay, counsel.
Morning, Judge.
I
How are
never
you,
realized
sir?
it. Thank you for saying something. All right, Mr. Billings, I'm going to give you a PR bond today. There's a warrant for your arrest, so I'll give you a PR bond today, but I want you to understand, I don't continue to give PR bonds after PR bonds, especially if you're a danger to my city. I'm going to give you one now, but there won't be multiple ones. You understand? Okay, all right, you're done. Thanks.
All right, so just have a seat and please follow the motion.
Hey, Jay, what's up, man?
Morning, Judge. How are you, sir?
It's been a while.
Yes, sir. I'm doing well. I'm here on Matthew Owen this morning. I'm here for Mr. Pulowski. He's across the hall doing a plea. It's been my understanding that he has been accepted into PTI. He's done his TRAS. We've gotten the TRAS back. We're just waiting on the contract from the DA's office.
Cole, what say you on Mr. Owen?
I do have a note here. We have the TRAS saved, and I have a note from today at 9:02 a.m. that it says DWI PTI insurance expires 9/18/25. I'm not sure if that's the valid insurance that he had to submit or something.
I believe it would be.
Okay, and then that's the latest I have on that, so I guess we haven't gotten a contract.
You're not going to get it, I guess, until they give you get insurance.
That's what it sounded like.
So we'll set you off for a week. Okay?
Yes, sir.
It's getting old. It's 190, so no more waived appearances. If you get everything done, then I'll waive it, but if not, he's got to be here.
Absolutely. Yes, sir. Thank you.
Thanks, man.
Want this on the record, but I've thought about it. I don't think I'll need Metter again because he didn't say the inconsistent statements were a major player. So that's really I was going to focus on.
No, so let's just let him know. So, I mean, he felt awful. Let's just get him out of here, you know?
Yeah. And that he's got to work tonight too. So, yeah. So I'd rather just get him out of here.
That's good.
Just want to put that on the record.
Okay, quiet. We're going on the record. Please do not say anything. All right, we are back on the record in the trial case. And after speaking to both state and defense, both of you guys have come to the agreement that you are ready to release Deputy Metter, not subject to recall anymore.
That's correct, Your Honor. That's correct, Your Honor.
Okay. All right, so we'll let him go.
Thank you, Your Honor.
I guess we'll start here momentarily.
Okay.
Thank you, Your Honor.
Thanks.
Yes. You want to just informally? Yeah, we could do informal first and then.
Okay, sure. So we're not on the record now?
No, not right now.
Okay, talk to me.
So what I was showing him is the video from the intox room in JPC, where it shows that he comes in and then 6 minutes later is when he actually does the test. What they're informing me is that the observation period began outside, but there's videos from the outside, which we don't have. So there's no way of us to confirm the 15-minute observation period. I'm asking for these to come in just so I can make that argument. I think the state's going to object to it as to the weight of the evidence. That's so I'm just.
You're objecting to him having admitting this evidence?
I thought you said.
No, no objection to the videos coming in. No. If you want to do that, that's fine. I'll just, I'll go back.
Yeah, I'm gonna let it in regardless. I was gonna let it in.
I thought you said something about the weight of the evidence.
No.
I was saying if you are objecting to like some kind of a breath test, saying, well, the breath test isn't good because we don't have this video, I would just say it's not
Is there a time that delineates when he was actually arrived at the station?
No.
Come on, there has to be.
There's not.
There always is. They document damn near
The
everything.
offense report, man.
The offense report does, but he can't testify as to the offense report.
No.
Yeah, that's. Sarah, do you need anything before we start up? No? Okay. So let's go. You ready? No, I'm gonna see how far we can get, you know. Do you have any witnesses?
I don't have.
Yeah, just literally just have them eat, deliberate and eat. You ready?
What's the food?
Pizza.
That's fucking cool.
So I'm sure that they would run a get it and.
Page 4.
Hey, hi, Maverick. Come on up. How are you?
Good, you?
Good job.
Don't know what to do about Mr. Burnett or Mr. Bennett. I know that you said he had a prescription.
He does.
Right? But that prescription was from, what, 6 months ago or something?
I think he has he has numerous valid prescriptions. Do you not? Can I bring him up here and talk to him?
Yeah, but
He does.
otherwise I don't want him to use, you know? I mean,
I get that. That's where, and as a lawyer, it's hard for me to sit here and tell him like, hey, don't listen to, if the doctor's, again, I get the look and feel for these types of prescription, just give them, there's tons of pill mills in the city. I get that stance, but then it's also hard for me to say as a lawyer, well, how do I say that this guy needs it and this guy doesn't when I'm not a doctor? And so it's hard for me to tell him, hey, don't do what the doctor says when
when did we do our first?
I feel like I've been here once a week, every week for the last 3 weeks on him. But
that's what
I mean, it's fine. Yeah, I get it.
No, I mean, that's why they're so different.
And it's not,
I'm
not upset by that or anything, but.
Here's what I want to know. I want to know when it's going to stop. He's got a prescription. If I remember, it was for 90, right?
This probably sounds right. Yes, Your Honor.
So I want to know when it's going to stop because I'm not going to let it continue for the next 6 months. You've got 90. You're not going to sit here and tell me that 90 is going to last you for the next 6 months and that you're going to continue to use. It's not going to happen. Come up, Mr. Bennett. And what's the purpose for? Is it for an injury? Is it for?
I think it's for, I could have sworn he was in a motor vehicle accident, but what, are you on pain medicine for injury or what?
I was in a wreck, but I haven't been using.
You're still testing positive for it?
When the last time I tested positive?
Last week.
I wasn't positive for it.
No.
Oh,
tested positive?
We were here on, was it Thursday or Wednesday of last week?
Last week, I did not test positive.
This is Mr. Bennett. When was his last UA? Please. If you're clean, I'm jumping up and down. Really?
Of the 17th, you told me the same thing, and I went and did my drug test, and I ain't have it in my system.
Let's see. I don't know. The last one I
Got
showed.
an email that he did, so that's why I assumed that he did, but I don't know.
And that's what I got too.
Last time I did a drug test, it wasn't in my system. Where they shake the bottle and show you right in your face.
His last drug test was on the 22nd, so it was yesterday.
And
no, I didn't.
Results?
They were presumptive positive for THC.
That's it?
That's it.
Okay.
Wonderful. That's great. I'm proud of you. Great job. Great. I'm going to test you like crazy still. Don't use. Please. I'm going to let you go for the time being for the weed. But, after about 50 days, if you're still testing positive, that means you're continuing to use. Just don't. All right?
So.
Okay, we're good. I'll continue supervision.
Thank you,
Okay,
Judge.
great. All right.
Is it like a report because June 3rd?
Say it again.
I haven't confirmed the declaration just yet. I have the declaration downloaded on the computer.
Okay.
Can we play the declaration on the computer?
Sure. I mean, as long as you're okay with it. Yeah. You mean how? Well, what is it for?
This is the body cams.
Okay, you want to do it? Just kind of show it to them, I guess? Like put it up on the podium here or?
Or we can put it through.
Oh, there?
Yeah.
Oh, okay. Yeah.
I don't care.
Yeah. As long as you're okay, both parties.
This is where it's going to go back. All right, so this is State's Exhibit 2. Yeah, State's Exhibit 2. What was he saying there? That he was helping someone to move. Helping somebody to move, correct? Okay. But you didn't tell Officer Metter those words, did you? I said he was helping a friend move. Sorry? I said that he was helping a friend move. At this point, you said that?
Entonces, apenas digamos, lo repartimos lo que tiene que mudarse porque estamos, he said the things completely use of the now, and just got there for the site. He's coming from Cleveland or he's coming from South Oh, so he's saying, you take the Cleveland and do something that starts getting find out, you know, we're down here because the gas is cheaper. And we like,
Okay. You heard him say earlier that he was going to his friend's house, correct?
That's correct.
You didn't translate that to Officer Mender, correct? At this point? You just said he came down here for gas is cheaper, right?
Well, I mean, he said he was over for a movie in Spanish, and I told him that he was coming from Cleveland, they was coming from there, and then he came from here. The whole statement that he provided was very.
I'm not, the state can ask questions if they need to. What I'm asking you is, your translation was not entirely accurate as to what he was saying, correct?
Are you referring to, was it verbatim?
Yes.
It wasn't. It was paraphrased.
It was paraphrased, correct?
That's correct.
So some things were left off, correct?
That's correct.
Okay. And then later on, and as far as different languages in understanding slurred speech or noticing slurred speech, it's possible that even if you don't speak the language, you can still tell if somebody has slurred speech, correct?
That's correct.
Nothing could be wrong.
May this witness be excused?
Yes, Your Honor.
All right. You're done. Thank you so much for testifying. Stay safe out there. Do you have one more witness?
Two more witnesses, Your Honor.
Guys, you want to go through one more? What say you? Keep going? Lunch isn't here yet anyway, so. Okay, State, call your next witness, please.
State calls Donald Varner to the stand, Your Honor.
I still live in the court. I'm established.
Mhm.
I'm not established. And I'm not established anymore. I'm not established.
Well, the only thing I don't think that is it has been altered in any way, you know?
That's fine. That's fine, Judge. There's still one missing.
Huh?
There's still one missing.
I don't know. I can't think of what you're.
I asked him to say, but if you have an objection.
Okay, I mean, just.
May I go to court ex parte?
Um,
I don't want. If I say it.
yeah, I mean, I just.
She lost her question. That would be interrupted.
Okay. Yeah, we're printing a charge for you. Is that okay?
I want to ask for a specific instruction. I want to put the case law for that instruction.
Which
3823.
I'll give it to you. Yeah, don't worry. I'm gonna give it to you. Just, do you have one for me?
A case law?
Hold on.
Or- Oh, no.
Ramona. You have a 3821? Yeah.
Well.
No, it's from me. Take a trial in real life.
Hey. Oh, so. Thanks. You can stay. Yeah, so you're not.
I just.
Give me 2 seconds. 2 seconds. Okay.
All right, Mike.
Yes, sir. Miss Darcy Davis.
You're probably hungry too.
I know, I'm not done. I got
How do you do it?
Thank you so very much for being patient. I really appreciate it.
Yeah.
Thank you for coming. Thank you. Okay, so Ms. Davis, I guess you've had all the discussions, decisions, you know what you're doing. We've given you sufficient amount of time. You've now accepting this agreement where they've charged you with assault. You are pleading guilty to this offense. It's going to go on your record. It will be there for the rest of your life. You can never take it off. Like I said, from now on, you pick up any cases, you're likely to be looking at a minimum of 90 days in jail. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. Is this what you want to do?
Yes, sir.
How do you plead to the offense of assault?
We'll see, sir.
I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I'm going to roll your court costs so you won't owe anything, and good luck to you.
Thank you.
Thank you, Mike. Okay.
Thank you.
Yes, ma'am. Guys, you have an objection?
Yeah,
Tell me.
the state's gonna object to the 3823 objection, Your Honor.
Okay.
And the basis for the objection is that I'm gonna say that we, the state and defense, are not in disagreement to the factual basis of the stop. John told me that on direct examination, the officer testified that he ran the defendant's registration and observed that it was expired. Defense did not contest that on cross-examination. So I'd argue that the state and defense are in agreement as to the basis of the stop.
I did contest it, Judge. I asked him, I said, what you perceived was speeding.
Tested both.
Correct.
Yeah.
You perceived as speeding led you to running his plate, correct? Yes, I said, but if you hadn't perceived him as speeding, you would have not run his
I mean, he
plate, correct?
contested damn near everything. He did.
Okay.
Judge,
I'm going to overrule your objection. I'm going to allow it.
I understand the court's made its ruling. I would like to have that language reflected in the jury charge of those two areas for the basis of the traffic stop. The speeding and the expired registration, Your Honor.
Ray?
Okay.
Judge, I think that the speeding, I think it's fruit of the poisonous tree. When you go into the, are we on the record? When you get into the speed. When you get into the speeding aspect of it, again, the officer testified that if he hadn't perceived him to be speeding, he would have never run his plate. So therefore, I think that just the speeding alone is sufficient to say he didn't have probable cause to do either one. Either he didn't have probable cause to.
So why do you have a problem if they put both? You know?
Because I believe it would be misleading to the jury because I'm really contesting the reasoning behind it, the speeding. And then after he perceived the speeding, then is when he ran the plate. It's not that he pulls up next to him that he runs the plate. So I believe, but for the speeding, the plate would have never been run. And even the officer testified to that because I asked him, you were going the opposite direction, correct? So I think realistically, the biggest contested matter of fact is the speeding, which led to everything.
Okay.
So I believe a 3823 instruction with the speeding is appropriate.
I do have a response, Judge.
Sure.
So yes, defense is mentioned as fruit of the poisonous tree. I don't see any indication of how getting behind a vehicle that he thinks is speeding is any sort of search or any sort of privacy interest that exists in that mere fact alone. While he was
contesting the stop.
He's contesting the stop. Yes, correct, Judge. If I may, counsel, if there's two bases for the stop, then that should be reflected in the jury charge. It's
what's the 3823 just on the speeding?
Just on the speeding.
Am I right?
That's correct.
Okay, so I'm going to give you just that what you're asking for, right?
Judge, I believe the way it's currently reflected in the instruction would be misleading to the jury because it says before you may consider the evidence obtained as a result of Officer Metter's stop and detention, you must all agree that the state has proven beyond all reasonable doubt that Officer Metter reasonably believed that the defendant was speeding before Officer Metter stopped him. The state's arguing that it's not that he has to show that he was speeding and that's why he stopped him. The state's arguing that that's misleading because he can get behind him even if he thinks he's speeding. And then if he happens to run the registration before he initiates the traffic stop, which he did in this case, and it was expired, that is sufficient for reasonable suspicion and probable cause to initiate the traffic stop on its face. The way this instruction is currently written, Judge, it's asking like, well, if he wasn't speeding, then you suppress all evidence.
That is correct, Judge.
I mean, I think, I agree with that too, you know,
I
because
can
they
see-
do, if he wants to run the plate just because he wants to run it, he can do that. There's no law that prevents him from doing that.
Correct, Your Honor, and I can see that argument, which is why I specifically asked him, if you hadn't perceived my client to be speeding, would you have ever run his plate? And he said, well, I can run plates whenever. I said, in this particular instance, would you have ever run his plate? And I believe he said no. So if the court recalls on Dashcam.
I understand it. I get it. I
So
get it.
If my client had
But
just
still.
crawled through the intersection, he would have, Officer Metter would have continued straight. He was going to go straight.
How do we appease both of you in this situation?
Judge, let me tell you how this can happen. In the second paragraph on page 5 of the jury charge, it says you may consider this evidence, referring to the evidence that comes from.
Wait, where are you?
I'm on page 5 of the jury charge.
There's no.
Oh, sorry. It is under disregard evidence if unlawfully obtained. The second paragraph is just one sentence, Your Honor. You may consider this evidence only if you resolve a preliminary question in favor of the state. It then goes on to say that you need to address the issue of if they're speeding. That is going to inform the jury that they need to only consider the speeding and just disregard the other lawful basis of the stop.
You talking about the third paragraph?
The second.
No, it's where it says, before you consider evidence obtained as a result of Officer Micah Matter's stop, you must all agree that the state has proven the officer reasonable that the officer reasonably believed that Odier was speeding before Micah Matter stopped him, right? So, but there are other ways, right? Because he used in his testimony 2 ways. He also said that I did both. It's fair.
I can see that argument, Judge, but my position is still the same.
I get it. Yeah. So how do we put that in the language?
Judge, the easiest way to do that would be to say that, I'm looking at the bottom paragraph of that page, Your Honor. You must all agree that the state has proven beyond a reasonable doubt that Officer Micah Matter reasonably believed that the defendant was speeding or had expired registration.
Right?
I would still object for the same reason, Judge. I believe that the order expired registration is.
Okay,
for the
I guess I'm going to
poison
overrule your objection because we'll just put or registration, I mean, unless you have a better wording for it.
And or?
And or. Are you happy with that? Yeah, because it's and or. It could be or. It could be both.
Sure.
Yes. Are you happy with that?
That's fine.
Okay, done. So just put and or, and then after that, no objections from the state?
I saw, no, never mind.
Just a moment, Judge. I haven't read the last page here of the jury charge. Separated and, yeah.
He has, I think it should be 1, 2 should be physical now, 3 should be. That's how I perceive.
I do think that, it's been a minute since I've seen it.
I haven't.
I do think it would make it more clear to the jury if you have 1 mental faculties, 2, or physical faculties, 3 to point of birth.
Are you saying this should be separate?
Yeah, right, like 1, 2.
Oh, you decided to do it that way anyway? Yeah, it's back up. Okay, not a problem.
Yeah, I don't have to go to JPC.
See, this, you put this, put.
Yeah, no, absolutely. All right, I'm signing it for you.
I mean, I don't know. It's, that doesn't bother me one way or the other. Okay.
Is there another issue?
I don't think it's a huge problem, but if the state wants to address it, I have no problem fixing it.
I agree with defense, Judge. I don't see it's much of an issue. It's just that on the page.
On the definition of intoxication, Judge.
What about it?
I think, I would like to.
Okay.
Yeah.
Okay. We would just like to clarify that
to number it as 1, 2, and 3, 1 being not having the normal use of mental faculties, 2 being not having the normal use
Yes,
of
no, that's
physical.
right. It's got to be 1, 2, and 3. Right. Yeah. That's okay.
All right.
Yeah.
I have no issues with that, Judge.
Okay. So we'll fix those and then no objection. We get them in here. Yeah. All right.
No objections, Judge.
So it should be one.
Okay. Is it in mine or is it in there?
It should
Okay,
be.
I'll sign it.
But I think it's at the top of your queue right there.
Got it.
Oh, okay, okay, I see what you're
So
saying.
these just.
Give them
need to be
paragraphs,
memorized.
it's gonna have one big paragraph.
Correct.
Okay.
All right, cool. Thanks.
Today in Harris County Court, Miss Nunley faces a serious accusation after a traffic stop turns into a much bigger legal issue. Prosecutors allege that officers discovered suspected marijuana and a handgun inside a backpack connected to the defendant during the investigation. The courtroom now focuses on whether there is enough evidence to move forward and what conditions should be placed while this case remains active. With a weapon allegation involved, the judge must balance the defendant's rights with concerns about safety and future compliance. As the hearing unfolds, every statement and every condition placed on the bond could have major consequences moving forward. Stay with us as we break down this courtroom moment and the judge's
100
decision.
credit for 7 or what do you want to do?
He's got 73, you said?
I think-
How many days does he have? Sorry.
I think that's right.
I mean, I'm hoping for the 2
I get it. Well, no, but let's be prepared for the eventuality.
Yes,
If it does.
73.
Yeah, 73. So I don't,
It's 219.
So let's do like 210, just to make it clean.
210, yeah.
so that if it's, then that's
Just to make it clean.
Yeah, it's good.
And then I've already explained to him and his family, I'm like, regardless of what the verdict is, you're going uptown or up north.
discuss or mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of testimony of the witnesses and materials admitted into evidence. Nothing I have said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings. Ready? Do you mean to go back?
Meanings.
Okay. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meaning provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. You must follow these rules to request that testimony be read back to you. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it is requesting the testimony be read back, 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The verdict. The law requires you to render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on a verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. Oh.
We go about 30 seconds back.
Sure.
Sorry.
You want to go back from the verdict?
Maybe return a verdict only if all 6 of you agree.
Okay. So you may return, Tony, you ready?
Yes.
Yeah, okay. You may return a verdict only if all 6 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had testified or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. These are the rules that control your deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick a foreperson. The foreperson will preside over your deliberations and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves, then you must stop your discussions about the case until all of you are present again. You must communicate with me only in writing, signed by the foreperson and given to me through the officer that is assigned to you. You must not conduct any independent investigations, research, or experiments. Number 5, you must tell me if anyone attempts to contact you about the case before you reach a verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you've arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. Disregarding evidence if unlawfully obtained. You have heard evidence obtained as a result of a traffic stop and detention of Odier Alberto Gomez Santamaria by Officer Micah Metter. Specifically, you have heard the testimony of Officer Micah Metter and other state's witnesses, as well as evidence of a breath test suggesting that Odier Alberto Gomez Santamaria might have been operating a vehicle while intoxicated. You may consider this evidence only if you resolve a preliminary question in favor of the state. No evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America shall be used against the accused on the trial of any criminal case. The state must therefore prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. A police officer may, under the law, stop and detain a motorist without a warrant when the officer has reasonable suspicion that the motorist has committed a criminal offense, including a traffic offense. Before you may consider the evidence obtained as a result of Officer Micah Medder's stop and detention of Odier Alberto Gomez Santamaria, you must all agree that the state has proven beyond a reasonable doubt that Officer Micah Medder reasonably believed that Odier Alberto Gomez Santamaria was speeding and or had expired registration before Officer Micah Medder stopped him. If you find that beyond a reasonable doubt, then you may consider all of the evidence obtained as a result of Officer Micah Medder's stop and detention of the defendant. If you do not find that fact beyond a reasonable doubt, then you will disregard all evidence obtained as a result of Officer Micah Medder's stop and detention of the defendant, and you will find Odier Alberto Gomez Santamaria not guilty. The law on driving while intoxicated. You are instructed that a person commits the offense of Class B driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospital, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Intoxicated means, number one, not having the normal use of mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Two, not having the normal use of physical faculties by the reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Or three, having an alcohol concentration of 0.08 or above or more. Alcohol concentration means the number of grams of alcohol per 210 liters of breath. You are further instructed that if it is shown during the trial that an analysis of the specimen of the person's breath showed an alcohol concentration level of 0.15 or more at the time of the analysis was performed, then the person has committed the offense of Class A, driving while intoxicated. Or you are instructed that if you believe beyond a reasonable doubt that Odier Alberto Gomez Santamaria breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, you will find the defendant guilty of the offense of DWI misdemeanor 0.15 or greater and say so by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will proceed to consider whether the defendant is guilty of the lesser offense of DWI misdemeanor Class B. Class A, driving while intoxicated. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Odier Alberto Gomez Santamaria, on or about October 6, 2024 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, and you further believe from the evidence beyond a reasonable doubt that an analysis of Odier Alberto Gomez Santamaria's breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then you will stop your deliberations and find the defendant guilty of Class A, driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will consider whether the defendant has been proven guilty of Class B, driving while intoxicated, as instructed below. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant Odier Alberto Gomez Santamaria, on or about October 6, 2024 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of Class B driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will find the defendant not guilty. I've now signed the verdict sheet. Each side will get 20 minutes for closing statement.
Thank you, Your Honor. The state waives its opening and reserves its time for closing evidence.
Okay. Defense, you may start.
May I proceed, Your Honor?
Please.
I told you at the beginning of this case, in my opening, of the things you would not hear. I told you would not hear what his exact speed was. And I told you would not hear what his blood alcohol content was at the time he was driving. Out of all 4 witnesses that the state has put on, not a single one of them could say that with absolute certainty. Nobody can tell you either one of those facts. You heard from the analyst who said that he would need specific facts to determine what his alcohol level was at the time. He talked about absorption, how alcohol enters the body, how it takes some time for the alcohol to enter the body. And when asked, can you do that in this case? I believe the state asked him that. He couldn't. So we don't know what his blood alcohol content was at the time of driving. We know what they claim it was, or what the sheet shows it was at the time that he blew. That doesn't mean that's what it was when he was driving, right? Then he talked about the mental faculties and physical faculties. And the analyst told you that he believes somebody with a 0.08 loses all faculties. Right? And I asked him, does that include driving? He said, yes, I believe it includes driving. I said, would you expect to see other driving patterns? Would you expect to see swerving? Yes. Would you expect to see an accident? Yes. None of that happened here. It was supposedly speeding was the only issue, right? Now let's talk about the speeding. Officer Metter driving northbound on Southwest. He says he knows that intersection well because the station is not far from here. And he knows how fast somebody's going because of the flow of traffic that goes from here. There was not a single car on that road, not one. He admitted, my client had the green light. He didn't run a red light. In fact, we see him stop at the appropriate place at the next intersection. So it doesn't run a red light. There's no traffic to compare his speed to. Metter waits 10 seconds before even pulling out, or 8 seconds before even pulling out to go after him. And then when he does go after him, he claims he hit 64. He says that you can see that on the video. We didn't see that on the video. There's nowhere on that video does it show what his speed was. Why? Because we don't know what his speed was. That's just what he said it was, right? The evidence speaks for itself, ladies and gentlemen. Evidence speaks for itself. So then he says it's about a quarter mile to the next stop. So if he's doing 65, and my client's doing 65, he even admitted to you, Metter admitted to you, that my client would have been long through that next light before Officer Metter even hit it at a quarter mile. He was not doing 65, ladies and gentlemen. In fact, we don't know how fast he was going. Why don't we know how fast he was going? Because Metter didn't try to put a radar on him. He didn't try to do anything except pull out and say, I'm going to go stop this guy. And then when he gets up there, here's where the state wants you to say, oh, this is the problem. This is a reasonable cause or a probable cause for the stop. He runs his plate and finds out the registration was expired. Okay. I asked Metter specifically, is expired registration indicative of intoxicated driving? Of course not, right? It's a fix-it ticket. That's what you get. You gotta get registration, pay the ticket, case gets dismissed. So, and I asked him,
but for the fact that you perceive my client to be speeding, would you ever run his plate? He said, no. Why? Because he was going the opposite direction. He was going northbound, client was going eastbound. What's that? How to do the never eat soggy Wheaties? Yeah. So client was going westbound, complete opposite direction. So, but for matter thinking that he was speeding, he would never pull up behind him. He never pulled up behind him. He would never run his plates. He never run his plates. He would never have seen the registration was expired, and therefore my client would never have been pulled over. Let's talk about the investigation itself. When he pulls into the gas station, Metter realizes Mr. Gomez doesn't speak English very well, so he calls for a Spanish-speaking officer. Ruiz shows up. Ruiz starts talking to him. And Ruiz told you that he didn't translate everything verbatim. He paraphrased it, is how he put it. Metter testified that there were inconsistencies in my client's statement, which led him to believe that he maybe didn't have the mental use of his faculties due to intoxication, right? But there were no inconsistencies. Well, you heard Ruiz talk about coming out from Cleveland, helping the client move. Ruiz didn't translate that all. All he said was he came from Cleveland and he helped a friend, right? Then later on, he says again, he helped a friend move. And then Ruiz says that. And then Metter tells you, well, that's an inconsistent statement. He told you he came down to get gas. He was coming from his house to go get gas because gas is cheaper on the side of town, right? That's what that's what the client said, right? And Ruiz said that. Officer Metter says, oh no, that's an inconsistent statement. He never said anything about getting gas before. He said he had come down, helped a friend move. He said that the first time, and he said it the second time. And then they asked him, well, where is he going? He said he was coming down here to get gas because it's cheaper, right? So he came to get gas because it's cheaper in that thing. Then Metter goes on to talk about, oh, I pass all these gas stations. Well, we all know there's gas stations everywhere. Every single gas station has a different price. I know I've got my favorite one I always go to, and I will pass a dozen other stations to get to that one to get the cheapest price on gas, especially nowadays, and especially coming into the summer months. We all know that. So everything that Metter told you or used in the totality of circumstances is perfectly reasonable. Now let's talk about the field sobriety tests. They want you to start right here, like this. Right? I'm struggling to do that. And I have perfectly good balance. You start here, and then you've got to do heel to toe for 9 steps, and then a series of small turns. I know the SFSTs inside and out. I was a prosecutor, I was a police officer, a prosecutor, and now a defense attorney. I've done these thousands of times. I've seen them thousands of times. All right? So I can do them. My client got one time on the instructions. Metter claims he took 8 steps instead of 9. Okay, maybe he miscounted. All right. And then a series of small turns. They expect somebody to do this to turn around. All right? That's not a natural movement. Everybody, when you turn around, when you're just thinking, I got to turn around and go back, you get to the end, you turn around, and you go back. No falling over, no stumbling, nothing. Just an unreasonable test that is perfectly unnatural for a human body to perform. And he claims that the National Highway Safety and Transportation Committee established these so that it would be difficult. Sure, maybe that's the case. But even a sober person, I believe he even said, somebody, what were his exact words? It was relatively easy for somebody who is not intoxicated. Not completely easy, Not perfectly easy, not easy at all. Right? Relatively easy for somebody who's not intoxicated. So the field sobriety test, useless. Absolutely useless. And then he talked about, him and Ruiz both said, there's a strong odor of alcohol on his breath. Right? But then I asked, if you have one, maybe 2 beers and have a strong odor of alcohol on your breath. Yes. I asked Metter, if you have 2 beers, are you intoxicated? No. And then we get to Varner, and Varner says it was a moderate to mild odor of alcohol on his breath. Which one's the truth? We don't know. We weren't there. But that's completely unreliable as well, because there's inconsistent statements. If Metter wants to use the inconsistent statements, that's an inconsistent statement amongst the state. These are the people that work for the prosecutors. This is their job. Their job is to find people guilty, for the state, not the prosecution. Their job is to look for things to find people guilty. Right? That's what they try to do. So they're going to say what they want to say to get to that point. Now, as far as the jury instruction, there's a section in the jury instructions that says you are to disregard evidence if unlawfully obtained. Page, I believe it's 5. 1, 2, 3, 4, 5. Page 5. An entire section talks about evidence unlawfully obtained. I've already explained this to you, but I'm going to go over it again. Metter says he knows that intersection. Based on the flow of traffic, he believed my client was speeding. There was no traffic. He couldn't go after him. He couldn't tell how fast he was going. Then he goes out after him. A quarter mile later, he catches up to him and runs his plate. That is, without him thinking that my client was speeding, he would never run that plate. That's unlawfully obtained evidence. He just looked for something to find.
Objection, Your Honor. May we approach?
Why just lose it? I said, like 40 going after me. Or so. Okay, that's an ambulance. Right. And so so you can as well. All right. Come on. In 3 minutes.
So, again, speeding goes in behind one's plate. That tells you here down at the bottom, and or expired registration, right? What I'm asking you to think of is, why did he find out that registration is expired? What led him to that? But for him perceiving a speeding, he would have never run that plate. And if you find that probable cause did not exist, or as well as you don't believe that he lost his mental faculties, we didn't see him fumbling, we didn't see him walk, urinating himself, we didn't see him everything. During jury selection, I think somebody said that. You know, they urinate themselves, right? They stumble, they act a fool, they're belligerent, things like that. We didn't see any of that. What we saw were those unnatural field sobriety tests that are designed for people to fail. That's what we saw. Nothing else. No other driving facts. So no loss of mental faculties, no loss of physical faculties, And then they say, at the time that he flew, his alcohol was 0.153, but nobody can tell you what it was at the time he was driving. The law is driving while intoxicated, not intoxicated when you blow into the machine. Driving while intoxicated, which means they have to prove beyond a reasonable doubt that at the time he was driving, he either lost his mental faculties, lost his physical faculties, or was a 0.08 or higher. They have proven absolutely none of that. So ladies and gentlemen of the jury, you have one verdict and one verdict only. It's at the very top right there for you. We, the jury, find the defendant, Odier Alberto Santa Maria, not guilty. Thank you very much for your time.
Okay, thank you. All right, state. Thank you, Judge. Judge, may I publish a PowerPoint for the jury? May I publish a PowerPoint for the jury? Sure.
The key moment arrives when the judge addresses the bond conditions after finding sufficient probable cause to continue the case. Legally, probable cause is not a final decision of guilt. It only determines whether the case can proceed through the court system. Here, the judge focuses on preventing any future issues while the case is still open by placing restrictions connected to the weapon allegation. The defendant is specifically ordered not to possess a weapon, and the judge explains that violating these conditions could result in serious consequences, including being taken into custody. Do you think strict bond conditions are necessary when a weapon allegation is involved, or should courts wait until more evidence is presented? Let us know your thoughts.
All right. Defense said a lot of things. Some of it confusing. Some of it, right? Let's start with the jury instructions. This piece he pointed out to you said disregard evidence if unlawfully obtained. There's a piece I want to circle here. It does not say that you must all agree the state has proven beyond reasonable doubt that Officer Metter reasonably believed that the defendant was speeding. It says was speeding and or had expired registration. Ladies and gentlemen, this isn't hard. The officer thought he was speeding. He goes to the line, the officer sees him, he follows him, he tracks him, he pays him. Was it perfect? No. But he gets up to the line and he runs his registration. He finds that his registration is expired. That's all he needs. That's it, right there. That's what the jury instruction says. It says or. If you find that he had expired registration, it doesn't matter. Look at all the evidence. Now, let's go through this and let's make it easy. That's all the report. Every single person, except for the last witness, said that this occurred on October 6, 2024. That's an easy one. Let's cross that one off. The officers both said it was in Harris County, Texas, and in a public place. We know that it was this defendant. How do we know that? Because the officer said it was. Because the officer said, I was going down the road, I saw this car, I pulled him over, and he was the one behind the wheel, and you see him on the video. Let's cross off another one. Operated a motor vehicle. How do we know that? You saw it on the video. The officer told you everything you need to know. It's not hard. In a public place. You see on the video, he's at a gas station. The officer tells you he's at a gas station. And he's operating the vehicle on a public roadway. Straight from the officer. It's not hard. None of those are hard. And barely listening. Then we get to while intoxicated. This is still easy. Why is it easy? How do we know he was intoxicated? Because I have this piece of paper that says subject name that has the operator that you heard from his signature on it. And it says what his DNC was when he blew. Now, this is important. What does it say? Let's use the low one, 0.153. This is a smaller detail that you may not have caught, but you have to use your memory, think back. When the officer was telling you about the HGN, you remember there was a small part at the end of the HGN where he said, he was talking about the onset prior to 45. And it's what the officers used to calculate about where the defendant is on the scale. He told you what he thought the defendant was at that point in time was what? It was around 0.15. And then he went and got a breath test and he confirmed it. So it does. It doesn't have to be hard evidence. Remember yesterday we were talking during jury selection and I brought up Stonehenge and I said, and I told you, you might not have the full picture, but you don't need the full picture. When you get enough pieces together in a puzzle, you know what the picture is. And that's all this is here. We have all the pieces we need. Only thing left to really do. So go back in the jury room, take a form, and return a guilty verdict. That's what I'm asking you to do right now.
All right, thank you. All right, ladies and gentlemen of the jury, it's now time for you to deliberate. If you're going, do you mind escorting them to the jury room? Okay, all right, so good luck.
Judge.
Okay, we're in recess. I just want to remind him not to put the alternate in the room with them. That's what I was saying.
What was that?
Not to put the alternate,
Oh, okay.
because I always.
Then you gotta go take that stick.
Oh, right.
2, 3, 4.
Hey, come on. Oh, wait. Yeah.
We have states 1 through 4 and defense 1, right?
Weston.
No, the lady that came up.
Oh, that's what.
Did she come in tomorrow? Did she see the back on the tomorrow? What is it?
It's this judge signed the beats and bail around and the other ones.
No. We already told her she didn't come back. The Victoria told her, yeah, the 22nd of next year. No, she don't come back. No. So, yeah, I talked to her. Oh, I thought he was talking about the.
No, I'm
Okay.
Parks. Probably Parks.
He was hollering. Your Parks? Yeah, she gotta come back tomorrow.
Okay, well, you signed the bill around. I'm gonna have to.
Yeah, one time. He did not was on her. She finally came back.
Okay.
He probably supervision for the follower problems too.
Yeah, silence.
Just like.
Oh, nice.
Yes. Thank you. He was, sure, he, they knew that he was going to awesome, and we all knew he was awesome. Because he was going.
What was it?
Still see them.
Federal or
No,
state?
state, the two lead. But that feeling started.
No, I think the last year for the HPD. I got Gerald, Jerry Montcalm.
Yeah. In case the jury expands. Yeah. I mean, testimony, I want to hear. Oh, I see what you're saying.
I can't create wonders.
What?
Well, I actually feel bad.
Well, you shouldn't feel great, because everybody thinks so.
I appreciate that.
Yeah, I didn't see them all there. I always take care of a lot of juries, like some area county. It was like, screw this, let's just get out of here. Now I'm getting to you. So that's good. Thank you. They were both 10. That's the one we started off with. Yeah, we started from jury bank. Then one item was in some DWI trials where it was their strong state cases, you know, very minute not doing things. You have to be on Friday at 4 o'clock. Would you agree, Greg?
What's that?
I said, I think the jury's going, like, they seem like they're very fair, they're attending both sides of the court. They seem like they care.
Yeah.
So we're trying to be very wise. Yeah, so that's good.
Yeah.
And that was all your benefits.
Yes. Make sure. If you haven't used it.
Yeah.
But,
Yeah. Who was the DA at the time? Your previous one? Come on. Right after, show that department. Yeah. I think like we put 5 minutes on it's the right. No, I mean, yeah, it's, I only imagine.
We play a game? What time do you leave? You leave at 5 or 4?
4:30. Thanks. I never. I think. Oh, yes. But the way I look at it is your contributions all right. But oh, yeah, while you're in civil defense side, you know, so I just done it up over here, so okay. Yeah, so I didn't think about it. Yeah, I say that you can walk with stuff. I mean, I'm better. I'm like, yeah. And yeah, thank you. That's true. That's true. Because why I have it, that's a different. As soon as I got here, this is my company set up like started. And so you never need to. Always been going all for that. I knew I stuck something. I didn't do it. I need to back to the it's the programs you're doing. If you talk to money and medicine, they're like, how do you see this? You're sitting there, you know, but you got station case. He's in custody, he ain't getting him. He's bonded out first before he pays his trial.
I never tried. I would never want to try it. That should be. Was he actually prior offenders? Why? And just drop to a PCS. I'll try to go back to guys. Why would you burger? Yeah.
And they did it. So it's like, hey,
That's a harder thing, another thing to do in trial. You don't need to that.
WT, and only that's.
Yeah.
She would assign failure, and dismissal, and motion to dispose. Their children are duplicates, and one of them are parks. But I think they said,
Yeah.
could you install?
Oh, right.
Yeah.
Very good.
So on parks, is there anything else?
Parks, there's a king, there's a note under the motion to dispose. Yeah.
Got it.
And also days.
And what else?
The Joey's instructions for Ramirez, I pushed those through too soon, but we didn't have her come up today, we had her reset for tomorrow. Do you want us to do that tomorrow, so we have a PR going?
Yeah, I guess so. Not sign it?
Yeah.
Feel for your resources.
Of course.
It's like the last note, very frustrating.
I would want the exhibits.
Question? Verdict.
I'm assuming there's one.
Think it's a question?
Yeah, one question.
Yeah, but they always hit just one. They never did two. Mm.
You got a question?
Question?
Or we heard a ding. I don't know.
Hey, you guys? Yes.
Let me just see what if it's a question.
Okay, yeah.
Give me one second. I just want to keep on.
We're still on?
Yes. Okay, I think it did it right.
Yes.
Verdict. Hey, we have a verdict. Ramona. Let me go get Ramona.
Ramona states it's a and not a, did you prepare to file a stipulation of evidence?
For the, yes.
Yes, because we always need those before they get leaving.
Do we need it?
It just in case it's.
No, but I think we can just stipulate on, right?
No, we need to look at signature and the judge's signature and everything for the
The jury doesn't. That part.
Yeah, let me get him in first to sit.
Yeah. Okay. I thought you were talking about first. No.
Okay, you ready? Okay.
Yeah.
Oh, where's Tony?
No. Oh, wait, we need to.
Yeah, he went to go get it. Okay. Ladies and gentlemen of the jury, have you reached a verdict? Is it unanimous? Okay. I'm now going to read to you in the state of Texas, cause number 2532700, the state of Texas versus Odier, Alberto, Gomez, Santa Maria. We, the jury, find the defendant guilty of Class A driving while intoxicated as charged in the information. Okay, you've been found guilty. You may take a seat for a moment. Does anybody who would like the jury polled?
Yes, Your Honor.
Okay. Ladies and gentlemen of the jury, is this your verdict, man? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Your verdict?
Yes.
Verdict. Okay.
Thank you.
All right, sir. Just give me a second. Ladies and gentlemen of the jury, you have concluded your service. I thank you for everything that you've done. It's really an invaluable service. You may now retire to the jury room. If you give me a couple minutes, I'll come back there and talk to you, and then we'll try to get you all the things that you may need to get you out of here quick. Yeah. Thank you.
All right, for the jury.
Please be seated. Mr. Gomez, I want you to understand that you do have the right to appeal this verdict. If you decide to do that, there are certain timing requirements that must be fulfilled and documents filed. I can let your attorney explain as much as he knows, if that's something that you want to do, but timing is of the essence if you want to appeal this, but you do have that right. We do have to sentence, and if I'm correct, parties, you have agreed to a sentence.
Yes, Your Honor.
Okay, and the agreement is?
210 days.
With credit for the 73 days. Okay. I'm now going to sentence you to 200 days in jail. I will give you credit for 73 days that you have done. Mr. Gomez, you need to understand that this will now reflect as a conviction on your record. This now makes 2. If you ever pick up another DWI, you will be charged with a felony offense, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip of alcohol, get into a car and drive because you're taking a huge risk. Do you understand? Okay, so you may be seated, and I think that.
Are we going to keep it as a second with the Class A?
Yeah. Yeah.
So you're making sure, okay.
Yes. Well, they found it. Yes.
No, they found the .15 true. The second is an enhancement, which would need to be found true as well.
I thought we were stipulating.
Yes, we'll stipulate to the first.
Okay.
Doesn't change anything?
Right, okay, so we need him to sign documents, so just don't send them down until the documents are ready to be signed. I'm gonna suspend the license for a year, okay? Do not drive until you get a license. Otherwise, you'll be right back in custody.
Just for the record, Judge, although I've admonished him, well, the court admonished him that this could have negative effects on his immigration status.
Right, okay, yes, that's in fact true, right. You being found guilty of this DWI offense, this can and probably will impact any kind of immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You have an ICE hold now, so you know now that there are immigration consequences for future purposes. When you're on bond, don't violate, there are severe consequences, as you now know. Anything else you'd like? State?
Doesn't really say how.
No fines. Yeah, no fines, nothing else, just, I'll waive any kind of surcharges that will be imposed by the Department of Public Safety. Right, so if you don't mind, give me the motion and then I'll sign it for you.
Thank you, Your Honor.
Okay, all right, so just hang tight, but don't send them down just yet. Okay, all right, let me go talk to them real quick and then I'll let you guys go talk to them as well. We are done.
This hearing showed how quickly a routine traffic stop can develop into a much more serious courtroom matter. Miss Nunley appeared before the court facing an unlawful weapon possession allegation, and after reviewing the information presented, the judge determined there was enough probable cause for the case to continue. The court then focused on bond conditions, ordering that the defendant not possess a weapon while the case remains open. The judge made clear that violating these conditions could lead to an arrest warrant and additional consequences. This hearing highlights how bond decisions are often focused not only on the current allegations but also on ensuring compliance with court orders. The final outcome of the case will depend on future proceedings and evidence presented in court.